This is an appeal involving HM Revenue and Customs and Martin Frederick Fowler, in which HMRC appeals against an order of the Court of Appeal of England and Wales. It is taking place in a new way, which has been occasioned by the coronavirus pandemic. We are adjusting our working practices to make sure that the Supreme Court can continue to function while taking appropriate steps to comply with public health guidance and to minimize the risk of COVID-19 to court staff and users. This is the first time that this court has attempted to hear an appeal remotely so that the parties, their legal teams, counsel, and each of the justices can be located in different places during the hearing. Doing so will protect everyone involved from having to be in close proximity to each other for a prolonged period. It also assists in preventing the spread of the virus more widely. We do not know how effective this virtual court will be. Our trials of the technology on location last week have suggested that it should work. I ask everyone to be patient if we suffer unforeseen glitches and to allow our IT team to address any problems which we may encounter. The live streamed video will of course look different to our usual output, but we hope that it will serve as a satisfactory record of proceedings. We will make footage from today's hearing available on demand via our website within 48 hours. In order to reduce interference and echoes, may I invite everyone who is connected to keep their microphones muted when they do not intend to speak. If you do wish to speak while someone else is speaking, please indicate by raising your hand so that the speaker can see and pause to allow you to speak. When he or she does so, would the person who is then to speak please pause briefly before speaking? I turn then to the introductions. Unusually, I will invite my colleagues to raise her or his right hand as an introduction when I say their names before inviting counsel to introduce themselves. I'm Lord Hodge and I'm presiding over this hearing at the court in London. Each of my colleagues is taking part in the hearing from locations away from the court, and I will introduce them now. Lady Black, Lord Briggs, Lady Arden, Lord Hamlin. Thank you. May I invite Mr. Akash Nabat to introduce counsel and then proceed with the appeal. Thank you.
I appear on behalf of the Revenue leading Colm Kelly. My learned friend Mr. Schwartz appears on behalf of Mr. Fowler, the respondent in this appeal. My Lord, the issue in the appeal is which of the employment or trade articles of the Double Tax Convention applies to allocate taxing rights in respect of Mr. Fowler's diving duties from his contract of employment. Lord, I propose to structure my submissions by reference to first, the Double Tax Convention, second, the relevant domestic taxing provisions, third, the principles of treaty interpretation, and four, by reference to the OECD commentary. Lord, I ask the court to turn to the Double Tax Convention, that is in Authorities Bundle 1, Tab 1, page 163. You will see that the order bringing this or annexing the Double Tax Convention was 17th of December 2002. Annexes the UK South Africa Double Tax Convention. That convention is based on the OECD Model Convention. The 2002 Double Tax Convention replaced the 1968 South Africa UK Double Tax Convention, which was based on the then OECD Model Convention. The relevant history for your note is set out by the Court of Appeal in the Ben Nevis case at paragraph 30. And just the reference again for your note is Authorities Bundle 1, tab 14, page 245. The employment article of the 1968 Double Convention was in materially the same terms as the employment article in the 2002 Double Tax Convention. My lords, as I say, the Double Tax Convention is annexed to the 2002 order, and I propose to just take you through the relevant provisions, relevant treaty provisions. Can I first ask you to turn to or look at Article 2, which is at page 164. And you'll see that Article 1 provides, this convention shall apply to taxes on income and on capital gains imposed on behalf of a contracting state or its political subdivisions, irrespective of the manner in which they are levied. And you'll note that Lord Justice Lewison in the Court of Appeal placed some emphasis on those final words, irrespective of the manner in which they are levied. So the Double Tax Convention is not concerned with how a state that has taxing rights chooses to tax that income. Could I then ask you please to turn to Article 3 of the Convention, and that's at page 165. That sets out the general definitions. And there are in Article 3.1, there are just a few definitions I'd like to draw the court's attention to. Article 3, you'll see that Article 3.1 gives definitions, or at least partial definitions, for business and enterprise. You'll see Article 3.1d provides that the term business includes the performance of professional services and of other activities of an independent character. That provision was introduced in 2000 following the deletion of the independent personal services article, which I'll come on to address later. Prior to 2000, the Model Convention and indeed the UK South Africa Double Tax Convention then in force had separate articles, 14 and 15, addressing independent personal services and dependent personal services. In 2000, the independent personal services article was deleted because of the overlap with Article 7, the tax on business profits, or the article addressing business profits. And also a consequential amendment was made to the heading of the Article 15, the dependent personal services article. Although the body of the article remained the same, it changed its heading from dependent personal services to employment article. But that basic distinction between independent personal services and dependent personal services, as we shall see, carried on. I then ask you to turn to Article 3.1g, and you'll see that there the term enterprise is defined, and it says that the term enterprise applies to the carrying on of any business. And then H, you'll see the term enterprise of a contracting state and enterprise of the other contracting state mean respectively an enterprise carried on by a resident of a contracting state and an enterprise carried on by a resident of the other contracting state. And these definitions are relevant because they form part of Article 7, which is the trade article. Can I ask you then to turn to page 166, and you'll see that Article 2, subparagraph 2, addresses the position in respect of undefined terms. Article 3, subparagraph 2 says, as regards the application of the provisions of this convention at any time by a contracting state, any term not defined therein shall, unless the context otherwise requires, have the meaning that it has at that time under the law of that state for the purposes of the taxes to which this convention applies. Any meaning under the applicable tax laws of that state prevailing over a meaning given to the term under other laws of that state. So this article sets out how one addresses the interpretation of undefined terms, and you'll see that the relevant time is the time of the application of the treaty, not the time the treaty was entered into force. And you'll also see that it points one to the domestic law meaning, and it gives priority to the domestic tax law meaning. There is a conflict. Exemption, which is that the domestic tax law meaning will not apply if the context otherwise requires. In applying Article 3.2, the relevant questions are, what is the domestic tax law meaning? And if necessary, does the context require a different meaning? Now, although the taxpayer places substantial reliance on Article 3.2, you'll note that the Court of Appeal, the majority of the Court of Appeal, did not. I'll move then to I'll skip over Article 4. That deals with residence and questions of where you have dual residence. For our purposes, in respect of Article 4, the taxpayer is a resident of South Africa for treaty purposes. Article 5 deals with the permanent establishment. The relevant provision for our purposes is Article 5.3b. And you'll see it's applying that definition, applying that provision, the taxpayer would not have a permanent establishment. Articles 6 to 20 of the treaty then allocate taxing rights between the state of residence and the state of source in respect of different types of income or gains. Turning first then to Article 7, article that the majority of the Court of Appeal found applied to allocate taxing rights in this case. You see that Article 7 allocates taxing rights in respect of the profits of an enterprise. An enterprise is the carrying on of a business. Therefore, if the taxpayer is self-employed, then he would be an independent contractor in business on his own account, and Article 7 would apply. However, because he did not have a permanent establishment, only the state of residence would have taxing rights. You'll see that the last subparagraph is Article 7, subparagraph 6, which was considered by the courts below. What this paragraph says is where profits include items of income or capital gains which are dealt with separately in other articles of this convention, then the provisions of those articles shall not be affected by the provisions of this article. So this subparagraph gives precedence to other articles where there is an overlap. Because Article 7 covers contracts for services, and Article 14, the employment article, covers contracts of service, there shouldn't be, or one difficult to envisage circumstances in which there would be any overlap. The two articles should be mutually exclusive. If there was an overlap, Article 14 would take precedence. Then move to Article 14, please. That is at page 173. I said prior to 2000, the heading was dependent personal services. You will see that Article 14.1 is the relevant provision for our purposes. You'll see that Article 14.1 gives a non-exclusive taxing right over income derived from an employment to the contracting state in which the employment income is earned. The relevant term, which determines whether Article 14 applies to allocate taxing rights, is employment. So Article 14.1 applies to allocate taxing rights to the state of which the taxpayer is not a resident if income is derived from an employment and the employment is exercised in that other state. Therefore, there are only two relevant questions under Article 14. First, is the income derived from an employment? And second, if so, was it earned in the UK? If the answer to both those questions is yes, then the income is taxable in the UK under Article 14, and it is relevant how the UK chooses to tax that income. There is no requirement in Article 14.1 that the income being derived from an employment exercised in the UK, it must also be taxed as employment income. How the UK, under its domestic income tax legislation, deems or taxes income derived from employment does not affect its taxing rights under the Convention. And as I'll show you later when we come to look at the OECD commentary, that's not just in relation to employment income, that's a consistent theme when one comes to all of the articles. Employment, as I say, is the term which defines the applicability or scope of Article 14. It's not a defined term in the treaty, and therefore, pursuant to Article 3.2, we have to consider the domestic tax law of employment to see what income falls within the scope of Article 14. That is the purpose of the exercise under Article 3.2. That is to determine the meaning of employment, the term employment, in tax law. However, considering the meaning of employment in the treaty, it's relevant that the term employment is not just used in Article 14, it is used in other, and therefore, in my assumption, it's a relevant consideration in considering the issues in this appeal. The meaning of employment applies not just to Article 14, but other articles. Maybe Article 17, could I ask you to turn to page 174, please? You'll see that Article 17 deals with annuities. And you'll see that Article 17, subparagraph 1 provides, subject to the provisions of paragraph 18 of this convention, pensions and other similar remuneration paid in consideration of past employment and any annuity paid to an individual who is a resident of a contracting state shall be taxable only in that state. So Article 17.1 allocates exclusive taxing rights in respect of pension to the country of residence, irrespective of where the employment was carried out. If the majority are correct, that the majority of the Court of Appeal are correct, a former diver resident in South Africa receiving pension from a UK employer would not enjoy the protection of Article 17.1 because the payment would not be a pension in consideration of past employment. Instead, it would fall within Article 20. Could I just ask you to turn that up? That's at page 176. 20 is sort of residual category of other income. Virtue of paragraph 3, the pension would be taxable in both the UK and South Africa. effect of the majority's conclusion would mean that the object and purpose of Article 17, which in respect of a pension is to allocate taxing rights exclusively to the state of residence, would be undermined. That's recognised by the taxpayer in this appeal, although taxpayer says that's just simply a consequence of the legislation. But in my submission, it is important that here we are interpreting a treaty, and therefore one has to interpret that treaty as a whole. And so it is relevant to look at the consequences, the wider consequences of the interpretation, and in particular the interpretation of these undefined terms. Could I then move on to the second stage, the relevant UK domestic legislation?
I just wish to confirm with my colleagues, has everyone got their buttons muted? Because we are flicking, my screen is flicking from you, Mr. Norbat, to at least one of my colleagues. So can I urge my colleagues to mute their buttons to avoid the picture?
Sorry, do you mean F1?
F4. Thank you. Mr. Norbat, continue with UK legislation. Thank you very much.
Thank you. Can I start with the Income Tax, Earnings and Pensions Act, which is at Authorities Volume 1, tab 11. Sorry, wrong reference. Tab 7. And page 205. The court will be aware this is the act that imposes the charge to tax on employment income. The section 4, which is at page 205, you see that there is an express provision that defines the term employment. So section 4 provides in the employment income parts, employment includes in particular any employment under a contract of service. So first of all, the reference to the employment income parts, that is defined as all the parts of ITPA, excluding the part that this provision is in, part 2. And we can see from section 4.1 that for the purposes of income tax, this act and section 4 defines the term employment as any or including any employment under a contract of service. And in our submission, that provides the domestic tax law meaning of the term employment for the purposes of the treaty. The court will note that there is no signpost in section 4 to set any other provision, so no signpost to section 15 of ITOIA relied upon by the majority of the Court of Appeal, and nor does section 4 direct the reader to the application of section 15 as is contended by the taxpayer in his printed case. Section 4 in this respect can be contrasted with the term tax credit, which was considered in the Pirelli case. I don't propose to take you to that case, but for your note, that's A1 tab 22, page 383. But there, the term tax credit, the relevant domestic term or definition of tax credit itself signposted other provisions. and therefore necessitated consideration of a number of interlinking provisions to determine the meaning. As we can see, section 4 doesn't do that. The taxpayer in his printed case appears to accept that in the generality of cases, section 4 does provide the domestic tax law meaning of employment, and that is the meaning for the purposes of Article 3.2 in the generality of cases. Examples of that are paragraphs 26 and 55 of his printed case. The majority did not adopt that reasoning. In his printed case, the taxpayer seeks to draw a distinction between a definition and a meaning. And for your reference, that's paragraph 46 of the taxpayer's case. In our submission, if you have a definition, then that will provide the meaning. It is only if you do not have a definition that you need to look elsewhere for the meaning. In applying Article 3.2, the starting point is Section 4 of ITEPA. That provides the domestic tax law meaning of the term employment, and that is the end of the inquiry for Article 3.2 purposes. I next ask you to turn to Section 6.1. That's at page 206. And if I could ask you to turn to Section 6.1, that provides, well, the heading is Nature of Charge to Tax on Employment Income. Charge to the tax on employment income under this part is a charge to tax on A, general earnings, and B, specific employment income. And then this, the meaning of employment income, general earnings and specific employment income is given in Section 7. I'll come on to Section 7, which provides the definition or the meaning of employment income in a moment. But there is a subparagraph or paragraph of Section 6, subsection of Section 6 that's also relevant, and that is Section 6 subsection 5, and that's at page 207. And the court will see that it provides that employment income is not charged to tax under this part if it is within the charge to tax under Part 2 of the TOIA 2005 by virtue of Section 15 of that Act, diving and diving supervisors. So there is a signpost to Section 15. That signpost is in the context of employment income. And significantly, when one looks at sub 5, it says employment income is not charged to tax under this part if it, and it there is a reference to employment income, if employment income is within the charge to tax under Part 2 and 5. And so one can see that the premise of Section 6.5 is that the income to which Section 15 applies is and remains employment income. However, that employment income is charged to tax under TOIA, not ITEPA. It makes the employment income is charged to tax. Consistent with Section 15.1, which as of TOIA, which as we'll see provides that it applies to employment income, that is income derived from an employment. Defines employment income, and you'll see that at page 208. And you'll see that it provides subsection 1 provides the meaning for the purposes of the Tax Acts of employment income, general earnings, and specific employment income. And the reference to the Tax Acts includes relevantly ITEPA, TOIA, and also TIOPA. TIOPA is International and Other Provisions Act. We'll see that Section 7, subsection 2 provides that employment income means earnings within Chapter 1 of Part 3. That is a reference to Section 62 of IT, which you will find behind tab 8 at page 216. And there you'll see the familiar definition of earnings. And you'll get in those parts earnings in relation to an employment. So there we see the term employment means any salary, wages or fees, any gratuity or other profit, anything else that constitutes an emolument of the employment. And so income means remuneration derived from a contract of service. The definition in section 4 of ITEPA. Held by the FTT, section 62 ITEPA corresponds with the references to income in Article 4 of the Double Tax Convention. Move on to ITOIA, which is behind tab 10 to 220. And of course, ITOIA is the Income Tax, Trading and Other Income Act 2005. I should say that both the 2003 Act and the 2005 Act were parts of the tax law rewrite project. 2003, I think, was the first act that was redrafted, or was the outcome of the redrafting, and then 2005 is next. Can I ask you, please, at page 220, you'll see that section 5 is the charge to tax on trade profits. Income tax is charged on the profits of a trade, profession or vocation. So section 5 is a charging provision. It does not provide a meaning or otherwise define trade or business. Section 5 does not provide the domestic tax law meaning of business or trade. That domestic tax law meaning is supplied by the common law. Sections 9 to 15 of ITOIA bring within the charge to income tax under ITOIA certain non-trade activities. And relevant for our purposes is section 15, which is at page 224. Heading is divers and diving supervisors. And the court will see that section 15.1 sets out certain preconditions for the application of section 15. Section 15.1, this section applies if A person performs the duties of employment as a diver or diving supervisor in the United Kingdom or in any area designated by order in council. And so that would include the continental shelf. Importantly though, sub 1A, a person performs the duties of employment. The meaning of employment in section 15.1a is provided by section 4 of ITEPA. So 1a, this section applies to the diving duties that are performed. B, the duties consist wholly or mainly of seabed diving activities. And B, any employment income from the employment would otherwise be chargeable to tax under Part 2 of ITEPA 2003. So again, in 1C, the term employment income is, as we know, defined by section 7 of ITEPA that we've looked at. And the term employment, the meaning, the domestic tax law meaning, is provided by section 4 of ITEPA. So if one just looks at section 15.1a, we can see that section 15 only applies if the two requirements of Article 14 of the Double Tax Convention are satisfied. the diver performs the duties of employment, and those duties are performed in the UK. And as I've said, it is Section 4 of ITIPA which supplies the domestic tax law meaning of employment for the purposes of Section 15.1. 15.1b, Section 15.1b is that if it is only partly rather than wholly or mainly seabed diving activities, then that affects, then the Section 15 does not apply. Just to flag up what we say is an anomaly of the majority's construction. If you have two divers, one consists wholly or mainly of seabed diving activities, and the one who's only partly, although both are performed under a contract of service, on the majority analysis, Article 7 would apply to allocate taxing rights in respect of one, whereas Article 14 would apply to allocate taxing rights in respect of the other. Section 15.1c is very similar, we say, to Section 6.5. And it makes the same point, that it highlights the fact that Section 15 is dealing with how employment income from the employment is to be taxed, is to be charged. We say that the existence of those factual preconditions in Section 15.1 brings the diver's case squarely within the scope of Article 14, the employment article of the Double Tax Convention. So therefore, before you get to Section 15.2, Section 15.1 tells you that what is to be taxed is employment income from an employment, and therefore we say Article 14 applies to allocate taxing rights to the UK. Section 15.2 provides how the income from those duties will be taxed if those three conditions are satisfied. 15.2 is at page 225. Just before we look at subsection 2, you'll see that subsection 3 provides the definition of seabed diving activities. What we see is subsection 2 provides that the performance of any diving duties of the employment are instead treated for income tax purposes as the carrying on of a trade in the UK. So you'll note that section 15.2 refers to the performance of the duties of employment rather than the employment. And it is the performance of certain duties of that employment that are taxed as if they were income from a trade. Sorry, Lady Arden, I didn't hear your question.
I'm so sorry. In section 15.1c, this very short provision contains, subsection 2, this very short provision contains the word instead. Do you attach any meaning to it? Because this is a deeming provision which should not bear any meaning beyond that which is warranted.
Yes, and I say in my submission it means no more than as if. And in my submission links back to 15.1c. One has to read it. Any employment income from the employment would otherwise be chargeable to tax under Part 2 of ITIPA 2003. And so it simply follows on from that. and says instead it's taxed under.
But if one was looking at the limits of subsection 2, the word instead, therefore, should be instead of as provided in subsection C.
Yes. And that is the limit of the purpose, reflects the limit of the purpose of the provision as well.
Thank you.
And we say the limit of the extent of the deeming that is effect to the purpose.
Thank you.
That is the case is also reflected in the explanatory note. The explanatory note is at volume A2, page 638. So this is the explanatory note for the 2005 Act. There are some general notes at paragraphs 5 to 7 that explain the purpose of the Act. So paragraph 5, the purpose of the Income Tax Act, Trading and Other Income Act, is to rewrite income tax legislation relating to trading, property and investment income so as to make it clearer and easier to use. And then importantly this, at paragraph 6, the Act does not generally change the underlying law when rewriting it. The only changes to the law which it does make are minor ones, which are within the remit of the tax law rewrite project and the parliamentary process for the Act. Such changes are intended to clarify existing provisions, make them consistent, or bring the law into line with well-established practice. Sorry, Lord Hodge, I didn't hear the question.
It was page 638. Is it? And in my copy, it's 546. This is the Itoya explanatory notes.
Lord Briggs.
It is 638 in my electronic bundle, if that's of any help, and some comfort to council.
My electronic bundle is bringing it up as 536, but don't worry. If you give a number, we'll find. If you give a tab and volume number, we'll find the papers. Thank you.
So that's the starting point. And you'll note that there was a disagreement in the Court of Appeal. Lord Justice Lewison was of the opinion that if the majority's construction was correct, in fact, the tax law rewrite project in this case, in respect of divers, had led to a significant and inadvertent change, whereas Lord Justice Henderson was of the view that it did not lead to any change. Can I then ask you to turn to page 644, which is the last page of the tab, if that helps. There you'll see this is the explanatory note for section 15 of Itoya. So, and it's paragraph 102 of the note. Hopefully everybody has it. It provides, this section deals with activities which are,
Forgive me, intervention cancelled.
So this section deals with activities which are strictly the duties of an employment, but which, if certain conditions are met, are taxed as if they were the carrying on of a trade. It is based on section 314 of ICTA. And so in my submission, the explanatory notes demonstrate that the purpose of section 15 is simply to determine how the duties of the employment will be taxed. And you see the reference to which are strictly the duties of an employment, but which, if certain conditions are met, are taxed as if they were the carrying on of a trade. And you see the reference in the explanatory note expressly to the predecessor provision. It is based on section 314 of ICTA. And so no suggestion, consistently with the general intentions of the rewrite project, no intention to effect a change in the law from section 314. Section 314 is in A1, tab 5, page 199. Now, this was the provision that was in force at the time the Double Tax Convention was entered into in 2002. The court will see that it provides where the duties of any employment which are performed by a person in the United Kingdom or a designated area consist wholly or mainly A, of taking part as a diver in diving operations, B, of acting in relation to any such diving operations as a diving supervisor, the Income Tax Acts shall have effect as if the performance by that person of those duties constituted the carrying on by him of a trade within case 1 of Schedule, and accordingly Schedule E shall not apply to the emoluments from the employment so far as attributable to his performance of those duties. So it's clear in my submission that section 314 was not seeking to define business. The effect is simply the emoluments of the employment are taxed under Schedule D, not Schedule E. For the words according shall not apply to the emoluments from the employment if the deeming has the effect which the majority found, because there would be no emoluments from the employment. And of course, as the court will know, the relevant schedules, their function was to impose the charge to tax. They addressed how. For your note, the schedules under are in tab 4, page 192, and the relevant schedules are at pages 195. And tax under the schedule shall be charged in respect of. So, in my submission, it is clear that under section 314, the income remain. The effect of the deeming is not to supplant what no longer exists. Lord Justice Lewison, as I've said that if the majority are correct, the has unintentionally created a far-reaching and inadvertent change. 27 of his judgment, whereas Lord Justice Henderson at paragraph 43 stated that there was no change and the position would have been the same under section 314 of ICTA. In terms of the rationale, and because we're looking at a deeming provision, or to identify what was the purpose for which the provision was introduced, the rationale for this special tax treatment for employers was addressed in the FTT decision in this case. That is in the core volume, tab G, at page 145. The court will see at paragraph 94, the FTT identified that the exact purpose of the deeming provision contained in section 15 of ITOIA is difficult to discern from the Hansard extract quoted above. I'll take you to that paragraph in a moment. It is hard to see how dangers, vulnerability to long-term health hazards, and shortness of working life, for example, are relevant to the question whether the individual should be taxed on an employment or a self-employed basis. The real purpose of section 15 of ITOIA in my to be found in the more relaxed rules when compared with those for employment income for deductibility of expenses in the calculation of trading income, and possibly from the timing advantage conferred by the absence of PAYE. And you'll see that there's a footnote. One drops down to the footnote. One sees that the Office of Tax Simplification, in its review of tax reliefs in March 2011, identified the real reason for the introduction of this provision. So the provision was introduced how the tax was taxed, and principally the availability of deductibility of expenses. The Hansard extract referred to in paragraph 94 is set at paragraph 63 on 4. Read that extract to itself.
We will read the extract to ourselves if you give us a moment, and then you can continue.
The Minister is clear, the Financial Secretary to the Treasury is clear at the end that this is the income is to be taxed, assessable on Schedule D rather than Schedule E. And that's consistent with the wording that we've looked at in section. Although the divers benefited from self-employment, the deductibility of expenses treatment, they remained engaged under a contract of service. Insurance contributions deducted on the basis that they were engaged under a contract of service and therefore were employed earners. Our submission, the statutory purpose, which was to regulate how certain duties of the employment are to be taxed. Pointers as to the purpose, I propose to just look at two of the authorities on deeming provisions. The Supreme NTC Holdings Limited, which is A1 tab 15, and page 264 of the here the facts are relevant. I want to take you to the summary of the principles. Just start the head note at 6.5. Is the principle in the first 3 lines under the head. In construing a deeming provision in a statute, the application of any article of assumptions thereby involved was to be taken no further than was warranted by the purpose. So that's the principle one derives from this judgment. The relevant paragraphs of judgment identifying the principles are at pages 277 to 278. And it is paragraphs 37. Could I just ask, as I'm only going to 2 authorities on deeming provisions, could I just ask the court if it would mind reading paragraphs 37 to 39, please? And then I'll pick up the points I want to highlight.
Yes, we will do that now, and I'll raise my hand when I think everyone's read them. Thank you.
So, paragraph 37 contains a helpful summary of the facts in Marshall and Kerr, which is the next authority that I'll come on to. So I'll pick up those facts when we come on to Marshall and Kerr. An interesting point to note in Marshall and Kerr is that although the House of Lords in Marshall and Kerr approved the principle identified by Miss Justice Peter Gibson sitting in the Court of Appeal, in fact, their conclusion was that the Court of Appeal had gone too far on the facts in relation to the extent of the deeming provision in Marshall and Kerr. Paragraph 37, you'll see that there is a citation of the passage from Mr. Justice North's judgment in Metrolands. I just want to highlight the point: when considering the extent to which a deeming provision should be applied, the court is entitled and bound to ascertain for what purposes and between what persons the statutory fiction is to be resorted to. Just pausing there, when one reads the judgment of the judgments of the majority in this case, in our case, you will note that the majority concentrate on what they believe to be the effect of the deeming provision without any reference or identification of the purpose of the deeming provision. And in my submission, that was an error, whereas you'll see that Lord Justice Lewison expressly, in applying, identifies what the purpose of Section 15 is. And then carrying on with Mr. Justice North, it will not always be clear what those purposes are. If the application would lead to an unjust, anomalous, or absurd result, then unless its application would clearly be in the purpose of the fiction, it should not be applied. And so in my submission, that is an important and relevant caveat in this case. Then paragraph 38 sets out Mr. Justice Peter Gibson, where he identifies that the correct deeming provision to be to give the words used their ordinary and natural meaning, consistent so far as possible with the policy of the Act and the purposes of the provisions, so far as such policy and purposes be ascertained. And that picks up the point that Lady Gibson raised with me about the importance of in the deeming provision. Then you'll see at paragraph 39, there's reference to the judgment of Mr. Justice Neuberger in Jenks and Dickinson. And in my submission, what that paragraph does is it expresses a cautionary note about the extent to which a deeming provision should be applied. And in my submission, all three of those passages cited with approval by Lord Walker all address the limits of deeming provisions and how they should be correctly construed. Could I then ask you to turn to Marshall and Kerr, which is behind tab 21, page 371. The court will have seen the relevant facts were set out in Lord Walker's speech in DCC. Let's take you to the head note, which is page 359, which sets out in a bit more detail the relevant facts. Deals with somebody who died in 1977, who was domiciled and resident abroad. They, by their will, appointed a Jersey company as executor and left one half of their residuary estate to K, who was at all material times domiciled and resident in England. Within a year or two of the death, K settled some of her interest abroad. So, and the effect of the relevant provision 2411 was to vary the will so as to treat it as if this had been done by the testator. The taxpayer was assessed a capital gains tax in respect of the payments that she received. On the taxpayer appeal against the assessments, the Special Commission held that by virtue of the deeming provision, the bequeath's assets were deemed to have been acquired at the date of the testator's death by the company as legatee directly from the testator, and that since K was accordingly deemed never to have owned the assets, she had not been the settlor for the purposes of section 80. So that the effect of the deeming provision was to treat the act of K as never having happened. And you'll see that that was upheld by the Court of Appeal on the basis of the judgment of, as I'll show you, Mr. Justice Peter Gibson sitting in the Court of Appeal. He said you have to apply the inevitable consequences. Then can I ask you to go to page 371, please. You'll see that there Lord Lowry adds a cautionary note. He says the right way for a court to approach deeming provisions has been discussed, and reference is naturally made to the felicitous and wise observations to be found in East End dwellings, metro lands. Sound as the principles enunciated in those cases undoubtedly are, they can so easily lead a reader in the direction in which he was already facing. And in my submission, what that does is that does emphasize the importance of identifying the relevant statutory purpose. And so, again, that's why I say that it is significant in this case that the majority, in considering the extent of the deeming provision in our case did not identify or consider what was the purpose of the deeming provision in this case. Could I then ask you to turn to the speech of Lord Brown-Wilkinson, which starts at page 161. He gives the leading speech with which everyone agrees. The relevant passages start at 375, page 375. And you'll see at 375, Lord Brown-Wilkinson, he sets up the well-known passage from Mr. Justice Peter Gibson, and he describes that as being the correct approach in G.
My page numbers are different, so could you give the internal page authority as well, please? Thanks.
I apologise.
There's not a problem.
It should be page 164, internal page, and you'll see it. E to G is the that passage from Mr. Justice Peter Gibson, which Lord Brown-Wilkinson says identifies as being the correct approach. But then, do you see at G to H? He says he sets out how that principle was applied. Applying that principle of construction, he expressed his conclusion at 367. If the trustee of the very trust is treated as if the personal representative's acquisition of the assets, the subject of the instrument, had been the trustee's acquisition, one must surely, unless prohibited from doing so, also treat Mrs. Kerr as never having acquired or disposed of those trust assets. And in my submission, that's the equivalent of the majority's construction of the deeming provision in our case. And what we see when we go over the page, at page 376, is that Lord Brown-Wilkinson says that the Court of Appeal erred in treating the extent of the deeming provision so widely. You'll see about 6 lines down, towards the end of the line at B, it says, but he submitted, even if this is done, there is nothing in section 24 which requires one to postulate a state of affairs which renders it impossible for Mrs. Kerr to have been the settlor of the arrangement trust. I accept Mr. McCall's arguments, which require one first to identify what was the property settled by the arrangement, and then to ask the questions, and questions they're relevant to the particular provision. And if one applies that to our case, applying those principles, there is nothing in section 15 of Itoya which requires one to postulate a state of affairs which renders it impossible for Mr. Fowler or for the diver to have a contract of service and to be in employment, either for domestic or treaty purposes. What I propose to now is just to apply those principles from the authorities on deeming provisions to section 15, to pretend that the performance of certain duties, not the employment, constitutes the taxpayer carrying on a trade when in fact he was not. The manner in which the income derived from certain duties of the employment is taxed does not change the employment's basic characteristics, nor does it exclude the section 4 meaning of employment for domestic tax law purposes. Section 15 is not intended to, nor does it alter the actual status of the contract. It remains a contract of service, a contract of employment. It is significant in this regard that section 15 only applies to certain duties of the employment. Moreover, unlike section 15.1, section 15.2 does not refer to employment or employment income, but refers to certain duties of the employment. That is consistent with the fact that Section 15.2 does not require one to ignore the existence of the employment and the employment income derived from that employment. In my submission, it certainly does not provide any warrant for ignoring the employment and employment income for the purposes of applying the double tax convention. There is no suggestion or indication that the deeming was intended to extend that far. Section 15.2 describes what is treated as a trade as the performance of duties of employment. It only applies to that part of the employment income derived from the diver's employment that relate to the diving duties in the UK. For example, if the individual carries out some diving duties in the UK and some elsewhere, or carried out in week 1 some diving activities and in week 2 other activities of a different nature, 1, only some of their duties under the contract of employment would be treated for the purposes of UK income tax as the carrying on of a trade, and only part of the remuneration under the contract of employment would be taxed under Section 15 of ITOIA rather than Part 2 of ITIPA. Submission that reinforces the fact that Section 15 does not want to ignore or pretend that the employment and employment income does not exist. Wording of Section 6.5 makes clear that that is not the intention or effect of Section 15. Section 6.5 makes clear that what is being taxed under Section 15 is and remains employment income. It is simply taxed under Section 15 instead of being taxed under Part 2 of ITIPA. That's also reflected and consistent with the language used in Section 15.1c. Taxpayer is correct. Section 6.5 is otiose and unnecessary because there would be no employment or employment income in respect of which the charge in ITIPA could apply. Section 6.5 is necessary because Section 15 does not alter the diver's employment or employment income, and absent Section 6.5, the relevant employment income would be charged a tax under ITIPA. Moreover, the limited purpose and extent of the deeming provision is, in my submission, reinforced by the explanatory note and also the wording of Section 314. In terms of the explanatory note and the reference to the predecessor provision, the Supreme Court in Derry did consider these matters. That's at tab 24, page 446 of the Authorities Bundle 1. You'll see at page 449 see that at paragraphs 7 to 10, Lord Carnworth sets out a summary of the tax law rewrite project. You'll see at paragraph 7, he notes that in considering the interpretation of, in that case, the Income Tax Act, it is necessary, in my view, to have in mind its genesis as part of the tax law rewrite project. The main purpose of that project, as stated in the ITA explanatory notes, was, and then he sets out the relevant paragraphs from the explanatory note that I had taken you to. And then you'll see at paragraphs 8 and 9, he refers to, well, relevantly at paragraph 9, he refers to a judgment of Mr. Justice Sales in Eclipse, which likened the correct approach to statutory interpretation to that approach to a Consolidation Act, and that's Fowler and Alexander. And it's a point that's was picked up by Lady Arden paragraphs 85 to 86, which is at page 469. One starts at 85. Lady Arden says, in deciding how the court should interpret a statute, the type of statute as set out in the statute's preamble is a relevant consideration. In the case of the Income Tax Act 2007, the preamble provides that the Act is to restate with minor changes certain enactments relating to income tax and for connected purposes. Toya 2005 has a similar worded preamble. And 86, so ITA is not a pure or straight consolidation act. However, as the explanatory notes cited by Lord Carnworth confirm, it is not intended to change the law. Importantly, that is a matter which the courts must, in my judgment, respect when interpreting the new legislation. Notes that with this type of legislation, they get perhaps less scrutiny than other primary legislation. The respect to which I have referred to for giving effect to Parliament's intention, where it is possible to do so, is often expressed in terms of presumption in relation to consolidating statutes that Parliament did not intend to change the law. In our case, that is reinforced in the context of section 15 by the express words of the explanatory note in relation to section 15, which states that it is based on section 314. Whereas the language in section 314, the duties of the employment are taxed as if. Should go on to say that paragraphs 87 and 88, Lady Arden addresses the looking at the legislative history, Fowler and Alexander. Case doesn't concern the pure question of the construction of section 15.2. It involves a broader question, whether it provides the domestic tax law meaning of employment and whether its effect is to displace section 4 of ITPA. And so my submission, that is a broader purpose for which we are carrying out this exercise. Moreover, the note specifically directs you to section 314, the predecessor provision. Just in terms of the use of explanatory notes, I think from my learned friend's submissions in his printed case, he appears to potentially take issue with the use of explanatory notes. This is addressed in the Westminster City Council case by Lord Steyne. It's tab 25, page 474. And it's paragraph 5 is the relevant paragraph. I think my learned friend refers to paragraph 6. I just wish to draw your attention to paragraph 5. You'll see that in paragraphs 4 and 5, Lord Steyne addresses the drafting process and also the use of explanatory notes. And over the page at 474, he says, again, there is no need to establish an ambiguity before taking into account the objective circumstances to which the language relates. Applied to the subject under consideration, the result is as follows. Insofar as the explanatory notes cast light on the objective setting or contextual scene of the statute and the mischief at which it is aimed, such materials are therefore always admissible to aids to construction. They may be admitted for what logical value they have. Used for this purpose, explanatory notes will sometimes be more informative and valuable than reports of the Law Commission or advisory committees, government green or white papers and the like. After all, the connection of explanatory notes with the shape of the proposed legislation is closer than pre-parliamentary aids, which in principle are already treated as admissible. And that principle has been applied frequently subsequently. the relevant domestic provisions, there's just one final statute that's referred to. That is EOPA, which is at A1 tab 12, page 231. So this is the Taxation, International and Other Provisions Act 2010. You'll see that section 2 is the provision that gives effect to arrangements made in relation to double tax agreements. And over the page at 232, you'll see section 6, which sets out the effect given by section 2 to double tax arrangements. All this provision says is that double tax conventions have effect in relation to income tax so far as they provide relief from income tax. And so in my submission, contrary to my friend's submissions, this in my submission doesn't take on any further in relation to resolving the issue in this case. Those were my submissions on the relevant domestic statutory provisions. It's going to move on to the third stage of my submissions, the principles of treaty interpretation. I say that it's relevant to look at those principles because, one, both the case law and the OECD commentary emphasise that in allocating taxing rights, the treaty focuses on what is being taxed, not how a state chooses to tax. Second, a conclusion that Article 14 does not apply to allocate taxing rights in respect of income derived from dependent personal services is inconsistent with the object and intention of the treaty. The relevant principles of treaty interpretation are usefully summarised in the Court of Appeal judgment, or the judgment of Lord Justice Patten in Smallwood, which is at A1 tab 26, page 562. So this is the judgment of Lord Justice Patten. His judgment starts at page 562. The relevant paragraph starts at page 572. You'll see that at paragraph 26, he sets out the well-known judgment of Mr. Justice Mummery in Commerzbank, which sets out the general principles derived from the authorities. Can I just take you to some of those that are relevant? Sub 1, it's necessary to look first for a clear meaning of the words used in the relevant article of the Convention, bearing in mind that consideration of the purpose of an enactment is always a legitimate part of the process of interpretation. A literal approach to interpretation is not appropriate in construing legislation which gives effect to or incorporates an international treaty. Then sub 3. Among these principles is the general principle of international law, now embodied in Article 31(1) of the Vienna Convention, that a treaty should be interpreted in good faith and in accordance with the order to be given to the terms of the treaty in their context, and, importantly, in the light of its object and purpose. Then can I ask you to look at sub 5? And that deals with subsequent treaties, so commentaries that the OECD produce after the entering into force of the convention, subsequent commentaries on a convention of treaty persuasive value only, depending on the cogency of their reasoning. The taxpayer in this case suggests at various points in his printed case that it's inadmissible to look at subsequent commentaries. In my submission, it's clear that from, for example, Commerzbank, and we've set out the other cases in our printed case, that it is permissible to consider subsequent commentaries. Could I then ask you to look at paragraph 27? That sets out Article 31 of the Vienna Convention. Article 31 sub 1 repeats this point about how to construe the object and purpose. You'll see there over the page at 574, there's a reference to sub 4. A special meaning shall be given to a term of it is established the party so I think if it is established the party so intended. My learned friend places some weight on that. We would say it's not clear that that applies to Article 3.2 of the Convention. Moreover, even if it does, it is, we say, still clear that Article 31.1, that general principle, does still apply to Article 3.2 of the Double Tax Convention. Can I ask you then to look at paragraph 28, which is at page 574? Can I just ask the court to read paragraphs 28 and 29 to itself, please? And the two principles that I derive from those two paragraphs are, first, Lord Justice Patten explains the purpose of the provisions to allocate the right to tax by reference to the situs or source of the taxable income or gain, or the place where the person is in receipt of the profit is treated as resident for tax purposes. But more importantly, in paragraph 29, the purpose is to set out rules for resolving issues of taxation, not to dictate how a state should tax particular forms of income. And in my submission, that is relevant to our case and the consideration of the relevant domestic provisions in our case. Can I just, as we're in Smallwood, just briefly take you to the FTT decision, which is also in this tab. My learned friend cites I think paragraph 99. Can I just, it's at page 146. Sorry, wrong reference. Sorry. I just, page 525 is the correct reference, I hope. Yes, 525, using the internal pagination at the top right, it's page 27. Sorry, so if we're in tab 26, using the internal pagination at the top right-hand corner, it should be page 27.
In the same tab. Thank you very much. Page 27. Yes, I have it.
And paragraph 98. There's just this reference to the commentary. 98 contains a helpful explanation of the commentary, makes the point that the treaty is based on the OECD Model Convention of 1977, has a commentary explaining the terms of the model, which is accordingly an important means of interpretation. Then you'll see towards the end of that paragraph, at the bottom of that page, it makes the point that the commentary now contains observations by a number of non-OECD member countries. So the commentary is produced and member countries have the opportunity to register observations or reservations in respect of particular paragraphs of the commentary. And as the FTT observed in paragraph 98, there is also now the opportunity and capacity for non-OECD member countries to also register their observations. That's relevant because South Africa is not an OECD member, but still has the opportunity, which it has taken, to register observations, reservations, but it has not in respect to the commentary that I'm proposing to take. Lady Black, did you have a question?
Yes, my bundle is, I'm afraid, not bearing any resemblance to yours. I think it's partly because I've not got the proper weeklies in it. I've got the print-offs from Lexis or Westlaw, and and I haven't got that FTT decision. So it may be that there are two versions on our system and I haven't got the right one. But can you just give me as much information as to where I'm looking in each case as possible, please? Thank you.
Sorry, Lord Hodge.
I'm in the same position, but I will, during the short adjournment, I will bring onto my screen the updated bundle. But if you give us the details of where to find it, we can check your references rather than hold you up. I agree with what Lady Black proposes. Thank you very much.
So reference to it, we were looking at 525 of the updated electronic bundle has a reference at the top of page 27. Lady Black, it should be in the. Do you have? Did you have the Court of Appeal report? Forward.
Yeah.
Yeah. So it should be. So did you see in the top right hand corner it had page 76?
No. No, mine ends with the next tab, which is the South African case with Lord Justice Ward, paragraph 74. Don't worry, we can catch up over lunchtime.
Can I just look at just that point I was making before about the application of Article 31 of the Vienna Convention to Article 3.2. That was also a matter that was picked up by the FTT in this case. That's in core volume, tab G, page 146. And the relevant paragraphs are 99 and 100. My friend cites paragraph 99, but you will see that at paragraph 100, the FTT observed that Article 31 of the Vienna Convention applies to Article 3.2. So that in applying the provisions of the treaty as regards undefined terms, the right of a contracting state to apply the ordinary meaning which the relevant term has under domestic law is subject to the general requirement of good faith and the need to have regard to the object and purpose of the treaty. And in my submission, that's a correct statement of the position. Therefore, in construing and applying Article 3.2, one has to consider the object and purpose of the treaty. And if the taxpayer is correct, it would lead to a result which was contrary to the object and purpose of the treaty, which is that if the taxpayer was an employee and derived income from an employment exercised in the UK, Article 14 would apply to give the UK taxing rights. I just want to move to the last stage of my submissions, those relating to the OECD commentary. Lord Briggs.
Just before you do, hear me. Should we be interested in or apprehensive about what strikes me as a possible consequence of the Court of Appeal's application of Article 3.2 in this case, namely that we would treat the income, if they're right, as not being taxable in the UK, whereas South Africa, unless it had an internal South African tax law provision about diving on the UK continental shelf, which seems prima facie rather unlikely, would also treat the income as not taxable in South Africa because Article 14 would apply, so that it wouldn't be taxable in either place. And I raised, as it were, rhetorically the question, is that an outcome which a treaty which is mainly concerned with double taxation is intended to produce?
Sorry, yes, and indeed we know in this case that the income is not taxed in South Africa because of the foreign earnings exemption in relation to the UK employment income. And in that respect, it's significant in my submission that reciprocity and the intention and the need to construe the treaty with that reciprocity in mind is emphasised by Lord Reid in the Anson case, which is at tab 23, page 430. So you'll see at 430, at paragraph 56, there's a summary of the principles of treaty interpretation, which is consistent with the principles summarised in Smallwood. Towards the end of his speech, you'll see that Lord Reid says at paragraph 110 and 111, which is at page 443, paragraph 110, Lord Reid says that the treaty should be construed in a manner which is international, not exclusively English. And then 111, that approach reflects the fact that a treaty is a text by negotiation between the contracting governments. The terms of the 1975 Convention reflect the intentions of the US as much as those of the UK. They are intended to impose reciprocal obligations. And then he goes on to say, in context, one would be predisposed to favour an interpretation which reflected the ordinary meaning of the words used and the object of the convention. But it's just that principle of reciprocity. And just as we're in Anson, you'll see paragraphs 113, 114. Now, there is this caveat. In Anson, they were considered words that were not defined in UK domestic law. But you'll see at 114 the reference to the need for a degree of pragmatism in the application of Article 3.2 if the objective of the convention is to be achieved. Hodge.
Yes, I had a similar query to Lord Briggs, because there are two purposes of this convention. as I read the opening words of the convention, where it says it's to avoid double taxation and also the prevention of fiscal evasion. Is the consequence of the majority interpretation that UK diving income is taxable neither in the UK nor in South Africa? I've lost your voice temporarily.
Can you hear me? Yes. Those are my instructions. That is the position. The income from the UK activities are not taxed in South Africa. Can I then, and so can I then go to the, as I say, the OECD commentary? Can I give you a reference rather than take you to it? It's page 525 to 526. That's the FTT in Smallwood. I'm just conscious that not all of you have it. And it's paragraphs 98 to 99, which I think is actually the paragraphs I took you to. That's about the relevance of the later commentary. But the paragraph, I took you to paragraph 98. At paragraph 99, the FTT make the point that it would be rather foolish to shut one's eyes to later thinking in relation to the meaning of the treaty. It's simply a matter of the weight and cogency that you give to the later subsequent commentary. So it's a question of weight, not admissibility. So can I go first to the commentary on the employment article? This is A2, tab 36, page 714. This is the commentary on employment. You'll see in the heading there's a footnote 1 after employment. And you'll see that there is the reference and source, at least in part, of the comments I was making previous position. And you'll see that the note records that before 2000, the title of Article 15 referred to dependent personal services. And then these are the words, by contrast to the title of Article 15, which referred to independent personal services. As a result of the elimination of the latter article, the title of Article 15 was changed to refer to employment, a term that is more commonly used to describe the activities to which the article applies. This change was not intended to affect the scope of the article in any way. So Article 15, the employment article, it's Article 14 in our convention, is intended to apply to, the object is that it applies to dependent personal services. And that is the distinction commonly known, or we commonly see between a contract of service and a contract for services, with somebody who provides services under a contract for services being in business on their own account, rather than the provider of dependent personal services. Could I then ask you to, and you'll see that that distinction that is familiar to us as UK lawyers between a contract of service and a contract for service is one that's used and reflected in this commentary throughout this commentary in Article 15. So starting first with paragraph 1, do you see it says paragraph 1 establishes the general rule as to the taxation of income from employment other than pensions, and we've seen that that is dealt with in Article 17, namely that such income is taxable in the state where the employment is actually exercised. So that's the general rule. The issue of whether or not services are provided in the exercise of an employment may sometimes give rise to difficulties, which are discussed in paragraphs 8.1 and following. paragraphs 8.1. But what we'll see is those difficulties that are referred to are those same difficulties that the court will be familiar that we have in UK law between the border between a contract determining on the facts whether a contract is one of service or for services. Then, so paragraph 8.1 is at page 725. And you see 8.1, it may be difficult in certain circumstances to determine whether the service is rendered in a state by an individual resident of another state and provided to an enterprise of the first state constitute employment services to which Article 15 applies, or services rendered by a separate enterprise to which Article 7 applies, or more generally, whether the exception applies. Now, that's looking at the fact that these two are mutually exclusive, Articles 7 and 15, the trade and employment articles. The exception referred to is the exception in Article 15.2, I don't think we need to look at. Do you see in paragraph 8.2, it makes the point that in some states, a formal contractual relationship would not be questioned for tax purposes unless there was some evidence of manipulation, and these states, as a matter of domestic law, would consider the employment services are only rendered where there is a formal employment. Then at paragraph 8.4, in many states, however, various legislative or jurisprudential rules and criteria, for example, substance over form rules, have been developed for the purpose of distinguishing cases where services rendered by an individual to an enterprise should be considered to be rendered in an employment relationship, in brackets, contract of service, from cases where such services should be considered to be rendered under a contract for the provision of services between two separate enterprises, contract for services. That distinction keeps its importance when applying the provisions of Article 15. So just pausing there, in my submission, that supports the fact that the premise of the convention, the distinction between Article 7 and Article 15, is that distinction between a contract for services, to which Article 7, the trade article, applies, and a contract of service, to which Article 15 applies. And then do you see this? It refers to the limits described in paragraph 8.11, and we'll come on to that because that deals with deeming provisions. Then, if one carries through, you'll see at 8.5, it makes the point that in some cases, services rendered by an individual to an enterprise may be considered to be employment services for purpose of domestic tax law, even though those services are provided under a formal contract for services. And so what this is looking at is those situations where you have in substance a dependent personal services relationship, in substance a contract of employment, but the form is, i.e. the formal contractual terms are provide that it's a contract for services. And again, something we see quite commonly in the UK domestic context. 8.6, in such cases, the relevant domestic law may ignore the way in which the services are characterised in the formal contract. It may prefer to focus primarily on the nature, i.e. the substance of the services rendered by the individual and their integration into the business carried on by the enterprise that acquires the services, to conclude that there is an employment relationship between the individual and that enterprise. Since the concept of employment to which Article 15 refers is to be determined according to the domestic law of the state, that applies the convention subject to the limit described in paragraph 8.11, and unless the context of a particular convention requires otherwise. Now, the limit in paragraph 8.11 is at page 728. You see it says this: the conclusion that under domestic law a formal contractual relationship should be disregarded must, however, be arrived at on the basis of objective criteria. For instance, a state could not argue that services are deemed under its domestic law to constitute employment services, where under the relevant facts and circumstances, it clearly appears that these services are rendered under a contract for the provision of services concluded between two separate enterprises. And then it addresses the exception in paragraph 2 And if you drop down to the line about 5 lines up, conversely, where services rendered by an individual may properly be regarded by a state as rendered in an employment relationship rather than as under a contract for services concluded between two enterprises, that state should logically also consider that the individual is not carrying on the business of the enterprise that constitutes that individual's formal employer. And so in my submission, this supports the fact that we're looking at for treaty purposes, in considering the term employment, and indeed in considering whether or not Article 15 applies, one is looking to the substance. Is this in substance, on the facts, a contract of employment, a contract of service? A domestic law meaning of employment, which excludes what in substance is a contract of service, would be contrary to the object and purpose of the DTC. Just finally, can I ask you to turn to page 736, please? This is the first of a number of paragraphs in the commentary in which the authors make clear that once the article applies, it doesn't matter how the contracting state chooses to tax the income. Sorry, Lord Hodge, I didn't hear.
Could you please give the paragraph number?
Of course, it's paragraph 12.4.
12.4, thank you.
Just ask you to read just down to just down to the bottom of the page. And so you see there that the employment article applies to the taxation of employment share options, even if those benefits are taxed domestically as capital gains rather than employment income. And that same principle is applied in respect of the other articles, and we see that that principle flows through the treaty. So can I just give you a reference? The relevant passages are set out in our printed case, paragraphs 51 to 53. And that's core volume, tab E, pages 57 to 58. Unless the court wants me to, I wasn't proposing to take you now to each of those paragraphs. As I say, they are set out in our printed case. Can I just take you to another, on a separate point, another part of the commentary? It's tab 32, page 689. This is the Article 3 commentary. That sets out the observations on the definition of business introduced in 2000. So that's the source, as it were, of the observations I was making on that Article 3, definition of business, Article 3L, I think it is, in beginning. Those were my submissions. There is, as I say, on Article 3.2, the majority didn't base its decision on Article 3.2. We do say in this case that if we're wrong on our prior submissions, the context would otherwise require, in order to maintain consistency with the object and purpose of the treaty. My learned friend seeks to give a narrow construction to unless the context otherwise requires. He relies on a UK partnership case, a case in which the Court of Appeal construed a partnership deed, case of Hammond and Jones. And can I just take you briefly to the upper tribunal in our case's rejection of that approach? So that is core volume tab G, page 115. Do you see paragraph 32? There's this reference to Hammond and Jones. You see at paragraph 33, Mr. Justice Marcus Smith says he doesn't consider that it applies. Unconstrained by technical rules of English law and by English precedent. In my judgment, although the use of the term requires might be said to import a degree of necessity, I do not consider this to be consistent with my duty to construe the double tax treaty as a whole. To my mind, it is necessary when considering whether a definition ought to be supplied by Article 3.2 to have regard to the effect of that definition on the double tax treaty. If the definition supplied by Article 3.2 results in an outcome that is either not sensible or not reasonable, then I consider that it should be disapplied. And in my submission, that is the approach to Article 3.2. Is there anything that I've not addressed the court on that any of the justices would like me to address?
Unless my colleagues wish to raise some points, as far as I'm concerned, you've covered the ground. Thank you very much. You've managed to do it in your allocated time, notwithstanding the technical constraints under which we've been working. Many thanks. Mr. Schwartz.
Thank you very much, Lord Hodge. One does need to think about the context in which the question has arisen in this case in order to approach it in a rather more balanced way than my learned friend has. But before I start, can I just check whether everyone has the same set of volumes? The bundles were revised because there were some authorities that were originally inserted that were incorrect, and that has caused the confusion, for example, in relation to the Smallwood case, because the version that was inserted originally did not have the Special Commissioner's decision, and others were incorrect. If I can just show you, this is the one. It says new core volume 1, and it's the word new that will tell you that you're looking at the right one. The authorities bundles also say new, and that is the reason for the mismatch in numbering.
Yes, Mr. Schwartz, you are right. There is a problem. Lady Black and I have been working from the older bundles. I have the new core volume. I have the older bundles. During the short adjournment, I will download onto my screen the electronic version of the new bundles. If you can bear with us till then, and Lady Black is going to come in to add something in a minute. Thank you.
I just wanted to say that during the process of what we've just been doing, I have checked the memory stick, both versions on our own electronic system of the bundle, and they're all in the same format that I've been able to find so far. So I'm still on the old bundles in every possible respect.
Well, we've managed so far, so hopefully it won't be too much of a difficulty. I think that it is really in the second half of the authorities that one gets into some difficulties in finding the pages. But the context of this case, I think, needs to be seen really in the way in which it arose, and that is originally about a dispute over the status of Mr. Fowler, and this appears in the Statement of Facts and Issues, which is in the core bundle. It's tab D, and it starts at page 37. And that's in both versions of the bundles. On page 38, at the top of the page, we have an extract from the amendment to Mr. Fowler's tax return, which sets out the reasons for that amendment. The inspector says, it is my opinion that when you work for Bibby, that you're engaged under a contract of service, employment, Article 14 employment income of the DTC applies to employments, and your continental shelf income is taxable in the United Kingdom. UK tax legislation treats the income as arising from a trade, but this does not alter the fact that the income derived from an employment. And that gave rise to a direction for a determination of a preliminary issue, because it was Mr. Fowler's case that that assessment was bad in law, because the contractual status of Mr. Fowler made no difference at all, whether he is actually self-employed or whether he's deemed to carry on a trade under Section 15 produces the same result. He falls within Article 7 of the treaty, and that being the case, determining the boundary between employment and self-employment simply doesn't arise. And that also indicates the approach that one ought to take to the case is not, as my learned friend did, to say that the relevant term to be defined is employment. Actually, one has to look at the treaty as a whole and simply ask the question, which is the relevant article to apply, and on what basis do we get to that? And the same issue comes up in other areas of domestic tax law where the boundary is resolved in terms of what the source is by legislation. And we certainly see this in Itoya Part 2 that my learned friend took you to for certain other types of income which are deemed to be trade. And Itoya is behind tab 10 in both of the bundles. It's at page 220. So if you look at page 221, farming and market gardening. Farming or market gardening in the United Kingdom is treated for income tax purposes as the carrying on of a trade or a part of the trade. And the reason for the statutory delineation of the source is because farming might be viewed as income from land, but that is resolved by statute in favor of trade. exactly the same approach we see in Articles 10 and 11 below that in relation to the commercial occupation of land. So 10 sub 1, the commercial occupation of land in the United Kingdom is treated for income tax purposes as the carrying on of a trade or a part of a trade. So any question as to whether that might also be income from land as opposed to income from trade is resolved by deeming it to be a trade. And exactly the occupation of woodland is there deemed not to be a trade. And this is really a very similar situation. As you know, the status of workers is now frequently under examination, particularly in the context of the gig economy. In this particular case, it is the legislation that resolves it in favor of trade and not in favor of employment. This is actually a very short point, and it is answered concisely and very coherently by the majority of the Court of Appeal, by Lord Justice Henderson at paragraph 38 and 40 in relation to the construction of section 15 of ITOIA, and in paragraph 43 in relation to the predecessor legislation. In paragraph 41, he deals with the relationship with the treaty. That is fairly lengthy, so I won't take you through those passages. But it is also a short point because Mr. Justice Lewison himself also accepted that the issue is really a narrow one that turns on the interpretation of section 15 of ITOIA. And for that, if we have a look at the Court of Appeal decision, which is in the core bundle behind tab H and, tab G, and it is paragraph 30, which is on page 98. And in the middle of that, he says, if the deeming provision has the effect for which Mr. Schwartz contended, namely that Mr. Fowler's diving activities were to be considered to be carrying on a trade for the purpose of the treaty, no one would suggest that the carrying on of a trade is outside the meaning of business. So, in fact, the Court of Appeal is unanimous that if this is the carrying on of a trade, then to follow what Lord Justice Henderson said, then all the other pieces relating to the interpretation of the treaty fall into place very simply. Now, one of the questions that was raised, and one of the points was that the majority did not rely in any large extent on Article 3.2 of the treaty, although, as you know, this is a central part of our argument. But the reason for that is actually a very simple one, and that is that the treaty exists both at the international plane as an agreement between the contracting states, but it is given effect in domestic law and domestic tax law by TIOPA Part 2. In other words, it has effect, it gives rights under domestic law, and therefore it operates at two levels. So at one level, one is interpreting the statutory instrument under which taxpayers have rights, and at the same time, one is interpreting the treaty. And in our submission, both of those converge and come to exactly the same result. the diver carries on a trade for income tax purposes under domestic law, including for the purposes of the statutory instrument, and the diver carries on a trade and therefore carries on business, which gives rise to business profits within Article 7 and not employment under Article 14. So if one follows what Mr. Justice, Lord Justice Lewison said, really one's got to focus on the construction of Article 15. And I would propose to firstly look at the domestic law and then have a look at the treaty provisions. And the starting point, I think, is certainly common ground, is that one needs to try to determine what is the purpose of Article 15 and indeed its predecessor. And for this, if we can go back to paragraph 63 of the first year tribunal decision, which is at page 126 of the core bundle, because that sets out the statement in Parliament relating to the introduction of this provision. And
Mr. Schwartz,
yes,
you keep referring to the construction of Article 15. Article 15, or are you talking about Section 15?
Apologies. My apologies. I'm talking about the interpretation of Section 15 of ITOIA.
Yes.
And this is really anchored starting at paragraph 10 of my printed case. Thank you for that.
I thought that's what you intended, but I wanted to be absolutely clear. Thank you very much.
No, Article 15 should not detain us. And if one looks at the middle of the quotation, what it says is, if I can repeat it, I recognize there are certain distinctive features of their work, such as the danger, which entails their vulnerability to long-term health hazards, exceptional traveling difficulties involved, shortness of working life. Taking into account these and other factors, my right honourable friend is now prepared to introduce legislation in the coming finance bill. And it is that language which suggests that there are many reasons for the introduction of this provision. It is not, as the footnote to paragraph 94, which cites the statement from the Office of Tax Simplification, simply a matter of employment. So the parliamentary statement, which was made at the time that the predecessor legislation was introduced, indicated that there were a number of factors. And it is for that reason that we say that the purpose of Section 15 of ITOIA and the predecessor legislation is to put employed and self-employed divers on an equal footing for income tax purposes, and to do so by treating them as traders. And in doing so, that would put divers on a par with self-employed persons generally and with other traders. And even if one were to take the view that Lord Justice Lewison and my learned friend have suggested, that it is simply in relation to employment, that does not lead to the opposite conclusion. It certainly doesn't suggest, as one might perhaps be thinking in relation to workers in the gig economy that they ought to be treated on a par with other employed people, it actually doesn't lead anywhere. In addition to that, if one looks at paragraph 94 of the first tier tribunal decision, where Judge Brennan discusses this, he rejects some of the reasons that have been given in his view and says that the real purpose is to be found in more relaxed rules for deductibility of expenses. And he cites for that the Office of Tax Simplification in March 2011, which says that the regime was introduced to ensure fairness among divers and nationality, of all nationality and employment status when engaged in the continental shelf. Now, firstly, that reference was not something that was matter of submissions by either party in the first tier tribunal. This was raised by the judge himself. We don't really know what the basis of that conclusion is. And it was also made many years after the predecessor legislation was introduced. So it's very different from, for example, an explanatory note to a finance bill, which may be an aid to construction, because it sets out the position of the government. But in addition to that, even if it is an aid to interpretation, it is certainly no substitute for the study of the language of the legislation itself. And there is absolutely nothing in the language of the legislation that supports the conclusion that this is simply related to employment expenses. It's not mentioned at all. And the comment from the Office of Tax Simplification, which is there to advise the Treasury, in other words, the executive, is also not by reference to the statutory legislation at all. So it is a very uncertain basis to come to the conclusion. And that is important because it is the purpose of the provision which seems to be the driving factor behind Lord Justice Lewison's conclusion that that the deeming does not extend to deem the divers to carry on a trade for the purpose of application of the treaty.
Was surely the Office of Tax Simplification was reporting on what they had found to be the contemporaneous evidence, and that one can look at it in that light as part of the matrix of fact surrounding the legislation.
The difficulty is that one doesn't have any of the surrounding information. What is it on which that is based? Is this something which is carefully researched? And perhaps one might deal with this by reference to analogy to the explanatory notes, and perhaps the comments that Lord Steyn made about explanatory notes in the Westminster City Council and National Asylum case, which is behind tab 25, and that is page 471 in the new version of the bundle. And there's no question about excluding it as an aid. The question is what weight can actually be put on it. And if one looks at paragraph 6 of Lord Steyne's speech, which is on page 474, he says there, if an explanatory note provides a clear assurance by the executive about the meaning of a clause, then it can certainly be cited. Well, I think if one adapts that, is there a clear statement about the meaning of a clause? Well, there isn't here, because it is not by reference to the statutory language. And he says towards the end of that paragraph, the aims of the government in respect to the meaning of clauses as revealed in explanatory notes cannot be attributed to Parliament. The object is to see what is the intention expressed in the words enacted. So even though one may consider it, the question is how much weight can you really attach to such a conclusion, which simply extracts some of the explanation from the some of the Hansard statement. Now, in considering the meaning of section 15 of ITOIA, the summary of the principles set out in the DCC Holdings case that my learned friend referred you to are extremely important. The first, and perhaps the central one, is that one must treat as real that which is only deemed to be so. And what is deemed to be so here is that a diver is deemed to carry on a trade instead of carrying on the duties of employment. One looks at the language of the provision, which is behind tab 10, and it is the deeming is on page 225. Performance of the duties of employment is instead treated for income tax purposes as the carrying on of a trade in the United Kingdom. Now, my learned friend spent some time talking about section 15 sub 1, which is on the previous page. Section 15 sub 1 is simply the subject matter of the deeming. That is what engages the deeming. And it is the employment duties that would exist but are instead treated as the carrying on of a trade. So that is the focus of the deeming. That is the reality that one has got to deal with. Now, my learned friend and Lord Justice Lewison said, well, it only deems the carrying on of the activities to be a trade, and it doesn't deem the employment to be a trade. Well, if I may skip ahead to the language of the treaty, I think that illustrates that even if one takes such a narrow and literal view of subsection 2, actually in context you come to the same conclusion, and that is by looking at the language of Article 7 and Article 14 of the treaty. And the most convenient place to see the two of them together is in the statement of facts. That is behind tab D of the core bundle. and they are reproduced at page 39. Article 7 sub 1, the profits of an enterprise shall be taxable only in the state of residence unless the enterprise carries on business in the other state through a permanent establishment situated therein. If the enterprise carries on business as aforesaid, then the profits of the enterprise may be taxed in the other state. So the focus of the allocation principle is on the carrying on of business. It is by reference to the activities. So if the diver is deemed to carry on a trade, and if trade is a subset of business, then that chimes entirely with Article 7 sub 4. If one looks at Article 14 sub 1, it is to similar effect. Subject to the provisions of Article 15, 17 and 18, salaries, wages and other remuneration derived by a resident of a contracting state in respect of an employment shall be taxable only in that state unless, so this is the equivalent of the permanent establishment test, the employment is exercised in the other contracting state. If the employment is so exercised, remuneration is derived therefrom may be taxed in that other state. In other words, it is the exercise of employment, and the exercise of employment is the performance or the carrying on of the duties, then that is the central feature in terms of allocation. So that if one is thinking about the meaning that is conveyed, even on this legalistic meaning, that is the relevant meaning. And this is supported by the OECD commentary on paragraph 1 to Article 15 of the model treaty, which is at tab 36.
Mr. Schwartz, I wonder, having looked at those provisions, would this be a convenient place to have the short adjournment, and we'll resume again at 2 o'clock?
As you wish.
Thank you very much indeed.
Thank you, my lord.
We'll end this session, and we'll all come back in for the next book meeting at 2 o'clock. Thank you very much indeed.